Okay, we are going to get started now. The time reads 4:03 p.m. That is Eastern time. We're going to get started with this hearing today. Good afternoon, everyone. My name is David Marusaris. I am a Deputy General Counsel for the Department of Local Government Finance, and I've been appointed by the Commissioner to act as hearing officer for this hearing. Assisting me today is Emily Chrysler, the DLGF's General Counsel, who will be assisting with the technical side of things. This meeting is being held virtually on Microsoft Teams. We are here today to conduct an administrative hearing pursuant to the laws of the state of Indiana as found in Indiana Code Section 36-1-10-14. This hearing is being held because at least 10 taxpayers in Allen County filed a timely petition with the county auditor objecting to a proposed lease by the county in an amount not to exceed $22,200,000 for the purpose of acquiring real estate and constructing improvements for a new jail facility, among other purposes. According to the auditor's certificate of the petition, a lease was executed on, hold on one second. Are you good? Okay, thank you. Sorry about that. Let me backtrack a bit. According to the auditor's certificate of the petition, a lease was executed on December 1st, 2023 between the county and the Allen County Building Corporation. A copy of the lease was provided to the department as part of the certification. The lease states it is to be paid by semi-annual installments over 20 years and payable by the following. First, local income tax revenues imposed and collected under Indiana Code 6-3.6-6-2.7, a local income tax for correctional facilities and rehabilitation facilities in the county. Also, second, legally available revenues appropriated by the county up to $5,925,000. Finally, a property tax levy if the prior two sources are not sufficient to pay lease rentals. Notice of the time and place of this hearing was given to the county and the first 10 taxpayers whose names appeared on the petition according to statute. Indiana Code 36-1-10 provides that a political subdivision may enter into a lease for a structure, transportation project, or system following certain statutory procedures if the annual cost for the lease is under or over $250,000. As of this time, as of now, the department has not yet received a copy of any resolution or action by the county officials on the execution of the lease, or of notice of public hearing, or notice of determination. The department, however, as stated previously, received a copy of the lease, which, like I said before, is represented to have been dated on December 1st, 2023. The petition has been filed with the Allen County Auditor, who certified the petition to the department on December 15, 2023. The petition requested that the department review the proposed lease pursuant to Indiana Code 36-1-10-14. Under this law, the petitioners must state their reasons why the proposed lease is unnecessary or unwise. Accordingly, the petition included several objections and reasons for which the petitioners believe the proposed lease is unnecessary or unwise. At the conclusion of this hearing, let me say first that this hearing, no substantive decisions will be made regarding the objection or the proposed lease. What will happen at this hearing is that it will be for receipt of evidence and testimony related to the objection. After the hearing, I, as a hearing officer, will make a recommendation to the commissioner on whether the lease is unnecessary or unwise based on any evidence presented and collected during this hearing, and also within the period as stated in the notice to provide supplemental evidence following the hearing. I will explain that a little bit later at various points throughout the hearing. The commissioner will then determine whether to approve or disapprove the lease execution in accordance with 36-1-10-14. So, following order of presentation will be used today. First, the department requested in its notice that people who wanted to testify at this hearing send a written notice to me prior to noon on January 3rd. Accordingly, persons who have timely indicated their intent to testify to the department will be allowed to do so at this hearing. Persons who have not done so may still submit written statements to the department. I understand that there was a typographical error on our website. We also stated this information on our website, saying that the notice of intent requesting to testify by noon today. I understand that is also communicated to the Journal Gazette. We clarified with the Journal Gazette that the intent to testify was by noon yesterday, January 3rd, and some other persons, interested persons who inquired about it. That being said, we don't want to make people feel like they are not being able to testify. We do want to maintain some order and make sure that we have the testimony from people who want to speak. So, which is why we requested in advance. That being said, we still have the opportunity for people to provide written statements. And as stated in the notice and on our website, and I believe maybe the Journal Gazette has communicated this as well, have until the end of the day on January 18th, so that's 2 weeks from today, to provide the department with some additional written testimony, whether you have spoken at this hearing or have not. Just want to make that kind of clear at the outset. So with that, for the people who have indicated their intent to testify, evidence, both written and oral, will be presented by those objecting. For the most part, this will be written evidence or oral testimony. However, if you have any written statements, feel free to submit that to us. You can be during the hearing or after, at your choice. All evidence will be cataloged and will become a record of the part of proceedings. Excuse me. Excuse me. So those who are objecting to the proposed lease will be allowed to speak, after which evidence will be presented by those on behalf of the county. Okay, so with that, just give a little bit more information about general procedures that will be observed. As we know, this is the teleconference hearing. If you are not speaking, we ask you that please mute your phone or your computer, however you're listening or attending. For right now, because we have so many people on, in order to kind of manage things a little bit better, we have everybody muted. So if you are called to speak, we ask you that you unmute yourself before you start speaking. Did I get that right? Okay. All right. Okay. So, but if you're not speaking, or if it's not your turn to speak, make sure that, if you've unmuted yourself, please mute yourself back, mute yourself again. So this hearing is being recorded, and there will be a transcript as well. Please speak loudly and clearly so that we may record your comments for the record. I will call one person at a time to present evidence. When you are called, please state your name and address clearly before offering comments. I expect all speakers to be truthful and state only those facts of which they have personal knowledge. Keep all comments focused on the main issue before us today, that being the proposed lease executed by the county. Those attempting to raise issues unrelated to the proposed lease will be interrupted and asked to focus. If a speaker continues to raise unrelated issues, I will ask you to immediately conclude his or her comments. Also, in the interest of kind of brevity and time, avoid repeating comments that have been offered by previous speakers. Issues need only be presented once to be considered. You may simply state that you agree with prior comments or give general support for a particular view. However, again, please don't just repeat prior testimony. Be kind and courteous to each speaker so that all may be heard. Don't speak out of turn, especially if you're kind of with a group of people listening in. Please don't speak out of turn. it won't serve any purpose. We have the ability to mute anyone. And if you're speaking out of turn, we reserve the right to put you on mute. Persons on the call may not ask questions to the person testifying or vice versa. I, as a hearing officer, will ask questions as I believe necessary. It is the responsibility of those offering testimony to raise issues and provide supporting evidence. As I mentioned before, if you have prepared written remarks, you may submit those as evidence either at this hearing or within 14 days following this hearing, which I said before is January 18. You may do so by email at hearings@dlgf.in.gov. Emily, can you please?
All right, then.
Thank you. It'll be typed into the chat window as well. And please include something like Allen County Lease in the subject line if by email. Alternatively, you can send it by mail, snail mail, to the Department of Local Government Finance, and we will be adding the address, physical address into the chat window as well, but I will read it out loud for those just listening by phone. By email, by mail to the Department of Local Government Finance, Indiana Government Center North, room 1058B, as in Barry, 100 North Senate Avenue, Indianapolis, Indiana, 46204. I believe this information is also on our website. I think our contact information is on our website. So that's, we also, you have the option to submit it by mail or by regular mail. Please, finally, please don't, we'll want to discourage as much as possible ex parte communication. So please do not call me or any employee of the department after the hearing is concluded to offer testimony. The only testimony we'll consider after this hearing is anything that is in writing submitted to us within that 14-day window. Like I said, up to the end of the day on January 18, and by end of day, I mean up to the stroke of midnight. So with that, is there any question about how the hearing will be conducted? If you can submit, like, kind of do a raise your hand, or excuse me, my throat is bad today.
You can also type any of those questions in the chat box as well.
Yes, as well. Give a minute if anybody needs any question or anything. Okay, so with that, we will begin with those who are in objecting. My understanding is that want to be called in a particular order. I will respect that. So first, and if I mispronounce anybody's names, I apologize in advance. So with that, Jorge Fernandez.
Yep. Okay. So, yep, my name's Jorge Fernandez. I am one of the.
Sorry, Jorge. Can't hear him.
Can you not hear?
Are you muted?
Hello? I shouldn't be.
Hold on.
Here, can you hear me? Huh. Abby says she can hear me.
You test it.
I hear something
I think
now.
we
Yeah.
might hear you.
Jorge, try again.
Yeah, hello?
I hear you.
We can hear you.
Yes,
Thank
please
you.
go ahead.
Okay, so my name's Jorge Fernandez. I am one of the petitioners. First disclaimer, I'm not an attorney, not authorized to give legal advice, if that wasn't clear enough in the petition documents. Obviously, the taxpayer objections, how the lease is unnecessary and wise is pretty broad. As you can see, they're included in the petition. A lot of the reasons a lot of the reasons are included in the petition. I kind of want to focus on some of the more issues with as far as the legality of it. There's three kind of major issues, I think, with the lease legality. The first one being as drafted. think it undermines county council's ability to guard against wasteful and unnecessary leases, specifically unnecessary leases, as described in 30 IC 36-110-7, which is part of the chapter that this petition process is also included in. So I think its proximity is relevant. Second one being how the controlled project process was not used for this. So I think the reasons why are questionable, and I'm going to raise those in the petition. I'm more confident about the interfering with county council's duty to protect against unnecessary leases, but I think the controlled project, not using that process is also an issue. And the Indiana Constitution's municipal debt limit, I understand that this building corporation is being used, and I think Barnes and Thornburg believes that that debt limit does not apply to it. But I think that building corporations, from documents the Public Access Council has put out, is considered a public agency if it's used for bond purposes. And so trying to understand that, how that wouldn't apply is another area of concern. So on the first issue, county council's duty to guard against unnecessary leases, one of the big things that I think falls under that umbrella is when the building corporation was actually created. So it was incorporated, from what I understand, the day after they went to county council to get the approval, I believe, that they thought necessary in IC 36-110-7. Kind of the documents that the resolution that county council approved as a county fiscal body, I think reflect that they felt that that approval was necessary under that part of the chapter. And the county commissioners apparently formed that building corporation the next day. And so the documents that were presented before council, based on the county council packet I have online, I don't have the specific documents that were presented to council, but based on the county council packet online, the exact name of the people in the building corporation, I think, were added to that template for the signature page based on looking at the execution of the lease, the signatures on the execution of the lease, just how that whole thing was laid out compared to what was actually signed. So just more evidence that it was created, following their presentation to council. And based on going on inbiz.com, looking at the Secretary of State when it was incorporated, it seems like they marked that as received or effective or something like that on November 20th. So I think the reason why the building corporation is important, because if the building corporation, for example, said in its bylaws that the members were only the county council and the county commissioners, then I don't think, I don't think you'd see that same issue as far as interfering with county council's duties, because then county council will be kind of a part of this building corporation. But given that it's 3 people that the county commissioners apparently appointed, and they're not, and that's not the case. That's not the case based on what I can find of the building corporation. I really do think that is much of an issue, because once you run into the contract clause in the U.S. Constitution, I think that'll create kind of issues in actually implementing this. If county council wants to actually investigate and find out the necessity of the project, which I think this would probably be a good time to quote IC 36-110-7, where it says, a leasing agent for a political subdivision other than a school corporation may not lease a structure, transportation project, or system unless, and then it gives 2 clauses, and it says, and the fiscal body of the political subdivision determines after investigation that the structure, transportation project, or system is needed. So it's really hard for me to see how a county council can say they've investigated this when they didn't even know what the makeup of the building corporation was. They got some vague verbal descriptions of it from the county commissioners presenting to them, I think on November 16th, but it wasn't really clear who would be on here. And it seems like they have some level of discretionary judgment based on the bylaws, based on the contract. So I think that's very relevant to what kind of structure we'll end up getting, which I think is relevant to the necessity of the structure itself. So, I think the commissioners here are flawed in thinking that county council gave, this a proper kind of one-time approval on this thing. But I also think it's the thinking is kind of incorrect as far as the fluidity that a one-time approval on this is just, on its own adequate, when the necessity of this, I think, is still being determined. It's kind of, you have all these different circumstances that play into the kind of necessity of the project, as I kind of described in in the petition. The current situations of the criminal justice system, state laws, all that I think plays into what the necessity of the structure will be. And so when the county commissioner or the county council asked, do we have to come back to you, or do you have to come back to us on this after we give this at least supposed approval for this? Do we have to come back to you, or sorry, do the county commissioners have to come back and ask for further approval? And the county council, Chris Cloud indicated that they would only have to come back for giving the courthouse, not for other aspects of the project. And so that's very concerning when there's so many parts of the project that have not been completely ironed out. I point out the bed count is only approximately 1,300 beds, but it's not clear as far as what the indication. I say only. I'm not trying to point out that that it's whether it's adequate or inadequate, but there's not a clear bed count on there. And then also, let me see. I'm trying to look back at the petition here for a second. I have it here. There's also the issue of the federal marshal's contracts. When the county commissioners obviously canceled that contract last year, but it was something that was clearly adding to the inmate count, housing inmates from jurisdictions outside of that the county was required to take in. And so I don't think in the contract there is enough safeguards against doing that. And I think that affects the necessity of the structure. If they are just, using all these beds in a proposed jail site, proposed jail, to house inmates from other jurisdictions, and there's absolutely no necessity for that for the county whatsoever, I would think, right? So I think, those kinds of questions, the kind of nebulous, the kind of vague descriptions of the project really kind of interfere with, the county council's ability to really investigate this and do its duty, because all it's given is approval at this point for some nebulous project. And, nothing, it hasn't really ironed out these safeguards to make sure that it's only being used for what it's supposed to be used for. The second point being the controlled project process. I think they're using two exceptions to, and I know kind of shifting gears here a little bit. On the controlled projects process, they're using kind of two exceptions to going through that process. One of those being that they expect to be able to use revenue other than property taxes. And when you look at the revenues being used here, the specifics of the draft language, it seems the only one fully committed is the jail lit. And so some of the questions that I raise in Appendix B in communications with the Department of Local Government Finance, I think are relevant. Is the jail lit for just 1 year, or is it locked in for more than 1 year? Because if the jail lit is just locked in for 1 year and not for like the 20 years of the contract, then presumably county council could reduce that rate. And also the lack, I think, of actuarial science, because I can't find evidence that there's any strong basis in actuarial science for projecting what the income taxes will be over 20 years. Maybe the county projected those, but I don't see like evidence that they have. So I'm open, because to hearing how they're so they feel so confidently that those jail lit revenues will be adequate. The obviously county council can appropriate other revenue. I think that's the second pot of funding that it would go to before property tax backup. But again, since that's optional from what I understand, I think the jail lid is what's committed. And so that question, I think, is very important to understand whether property tax will be used. And I think Baker Tilly, even when they did their presentations to county council on the need for a property tax backup in here, I think even I think kind of took for granted that, this project, absent a court order, would require such, because I think their understanding was that if a property tax backup was used, the only exception to going to remonstrance or referendum would be if there was an explicit court order. And so that brings me to the other exception that I think Barnes and Thornburg brought up, and I think even they admitted this was narrow, is to the extent that the project is related to a court order. And obviously, we know the kind of somewhat of the federal circumstances, involving the case as far as federal deprivation of rights. I'm not going to, kind of like speak to that, because that's a whole thing, and interpreting that rule, I think, is kind of a little kind of, would get us a little sidetracked here. But I think the county commissioners could easily put some language in here that makes clear, if that is the intention, if that is the stated goal, that this contract money is used only for that purpose, only for the exceptions listed in that part of the exceptions to the controlled projects rules that they're citing. So I don't know why that can't be explicitly incorporated in there. So that kind of covers that section. I think there's if we're looking at that section, the explicit guarantees towards the jail project, towards that is where the revenue will be going. There's a lot of other things here that could possibly undermine that. For example, the environmental issues with the site. If the money is going towards the remediating environmental issues, rather than to addressing the kinds of constitutional deprivations that might, that might be cited by a court, for example, then I don't see how that would be covered under that exception. I think every dollar that goes towards something other than that, that court, something the court is intending to do, is a dollar that kind of takes away from the necessity of this project, and it also takes away from obviously that the argument for that exception. So I think under the first two clauses, all the dollars that are not being going towards their intended purpose, and in a more broad sense, I think obviously I think that indicates, or that leaves the door open for waste. But definitely I think it goes to those two arguments. On the municipal debt limit, I'm that would be shifting gears again. If you're ready for me to shift gears here, I know you have. I don't want to take too much time. I've taken up 30 minutes here. If I guess I can speak briefly on the municipal debt, and then I'll let others. If I may, real quick.
Yeah, before you continue, Mr. Fernandez, just want to let everybody know, I don't intend, I apologize, I should have said this at the outset. I don't intend on imposing any particular time limit on somebody. I just ask that you just keep focused on the issues regarding the lease. Just so which I already mentioned. So if you are ready to kind of proceed, you're welcome to pivot, Mr. Fernandez. If you're willing, I'll let you speak say what you think you need to say. So just go ahead and continue.
Okay. All right. So on the municipal debt limit, I'm not sure of the assessed value. I mean, I think Article 13 of the Indiana Constitution, Barnes and Thornburg discussed that in their discussions with county council. I point that out, I think, in Appendix C. And so I think the spirit of that rule is, taxpayer protections, protect taxpayers from, getting overwhelmed by debt. And as far as the actual kind of, whether this violates it or not, I don't have, specific assessed value. I think I have an idea of what the assessed value in the county, the total assessed value for the Article 13 purposes would be, but I'm not sure. And the specific debt that would be counted as far as that. And I think that that's something that I think there could be further guidance on as to what debt would count towards the Article 13, because I think Barnes and Thornburg obviously I think has an interpretation that the building corporation doesn't count towards that. But just because other counties or other entities have used building corporations doesn't, I don't think necessarily means that any of them would have otherwise violated that rule. Maybe there's some that have and just it hasn't been noticed, but I don't think that's the case necessarily. So I didn't really see strong evidence that this been successfully used to avoid that debt limit, the building corporation. Even though I think that's the impression they gave to county council, was that this is why we have to do it this way as opposed to borrowing directly, because we have, it gets around the municipal debt limit. So I think there should be guidance to that, because I kind of would want to know where they get that, given the building corporation I think is supposed to be a public agency for public meeting purposes, for public records purposes. And if it's not, I would also like to know that, because I think that's relevant to any approval of this. It would not be good if this is not a public for the public participation. I don't think this would be good if it was not a public entity. So with a municipal debt limit, and I think it's getting close. I think it's definitely, this is a significant project, $22.2 million over 20 years. And I think that's a relevant question to whether this actually goes over. And if not, even if it doesn't, whether it approaches that. And I think that would go with why it would be unwise or unnecessary. I think that, the whole premise of this conversation. So again, since I've taken up 35 minutes, I will leave my remarks at that and let other people, and I'll just leave my remarks at that for now. Yeah, thank you.
Okay, thank you, Mr. Fernandez. I do have a couple of questions. Kind of early on, you were talking about the county, what the county council's action was. Can you clarify? You may have said, and I must have missed it. Can you clarify what the county council had considered and what was given, they may or may not have given approval for?
Yeah, so they were considering this, creating a resolution on the lease, from what I understand. And so the resolution, and I'm trying to pull up that resolution right now. The resolution that they said they had in the packet, and I'm assuming this is the one they approved, or sorry, this is the one that 4 out of 7 of the county council members agreed to, because I don't think it was unanimous. It says, now therefore be it resolved by the County Council of Allen County, Indiana, as follows. And it says section 1, findings, approval of lease, period. After investigation, the council hereby finds and determines that a need exists for the project, and that the project to be financed through the lease will be of public utility and benefit to the county. The council further determines that the project cannot be acquired, constructed, improved, and equipped from any funds available to the county. The county shall proceed to take such steps as may be necessary to secure the acquisition, construction, equipping, and leasing of the project as provided by Indiana Code 36-110. So this chapter is what they indicated. So I think it definitely points to 36-110-7 in that. But again, that's my comment outside of the actual text of it. But I think yeah.
Okay.
Go ahead.
Can you send me the copy of that resolution?
Yeah.
I'll ask the county as well, when they're going to speak, just because, like I said at the beginning, we didn't get a copy of that resolution.
Okay.
So I just want to make sure we have that.
All right.
You mentioned briefly the federal supervision, my understanding that there's a federal court supervising something involving this project. Are they supervising this project?
So the situation with the federal court is, I think, kind of vague at the moment. You have I think the ruling against the county, I think, is pretty clear because they've been found to have, there be deprivation, I think, of U.S. constitutional 14th Amendment rights, I believe, is what it is, and which the county commissioners, I think, for a while, or for the duration of the lawsuit, maintained until that ruling came down, that there was no deprivation, I think, of 14th Amendment rights, that it was not overcrowded. When I think, the sheriff's department said it was overcrowded. I don't think anyone, pretty much very few people outside of the county commissioner's office, that was arguing such, would have said that it doesn't have a problem with overcrowding. And so obviously that ruling came down, that was unacceptable. And so I think as a remedy, the federal courts have been, trying to find a remedy, within their purview, within, what they're allowed to do under, federal rules. And so there's, I think you have some like language that the judge has given in that ruling. But I don't know how much of that translates into an explicit court order. And so I think the contract probably should reflect that, anything being done in the project, if that's the stated intention, if that's what's being used as kind of an exception to the controlled projects clause, has to be explicitly kind of stated by the judge. This is related to the project. You can look at that exception to the controlled, projects clause, the one that involves court orders. I don't see any reason why the contract can't put more narrow safeguards to make sure that it's just being used for that, if that is the intended purpose. If it is, because then, I'm not going to argue that if it's used for that, the state, that's an exception to the controlled project clause, but it's just not clear from the contract that it will only be used for that. So, but yeah, I will send you that. The resolution by county council. Oh, that was it. Yeah.
Okay. Thank you. One more, at least one more. I'm still going to sit through my notes. You mentioned a determination by the public access counselor regarding building corporations. Do you have
the public access council document that I'm referring to?
Yeah. Yes.
I will. I can look it up. I think it's the Public Access Counselor Handbook, the most recent version. But I will look that up and get that to you.
All right. It's publicly accessible. I just want to make sure that if it's indeed the handbook, I'll go ahead and just kind of incorporate it as evidence now that will be considered as well. The relevant part of the handbook regarding building corporations. Yeah.
So on page 5 of the handbook, I think it's in building corporations are mentioned in a couple parts, but page 5, for example, says any building corporation of a political subdivision of the state of Indiana that issues bonds for the purpose of constructing public facilities is a public agency, because it says according to the provision, public agency means the following among others, and it has a colon and a list, and that's one of those on the list. Any building corporation of a political subdivision of the state of Indiana. Yeah.
And that's on page 5 of the public access handbook. It's available on in.gov/PAC, and I saw it right on the front page. So just wanted let the record show that that's being considered as evidence as well, specifically page 5 and that reference. Okay, and then you'll send me the resolution. Like I said, I'll ask the county for that as well. You made a comment about, and apologies, are most of your comments kind of that you stated kind of found in the petition?
In a way,
Okay,
the county council's duty I mentioned in the petition, and I think obviously I've kind of summarized
okay,
it, and I think
okay,
kind of got into more detail on it.
okay.
Like oh, if can I say something real quick? County council's duty, I say, we believe is unwise. Let me see here, where it says.
Well,
Yeah.
the reason why I ask is, if I'm asking questions and it's just stuff that I can find in the petition, I don't want to have to ask you to repeat if it's already in the petition. So I just want to make sure, because
Yeah.
specifically. Oh, sorry, go ahead.
The IC 36-110-7,
Okay.
I did not put that code because I was kind of unsure about,
Sure.
I think about citing some legal
Uh-huh.
code, just, I'm not an attorney. So,
Right.
but in Appendix C,
Okay.
I think I kind of talk about, and another is that it cuts county council and future county council out of decisions by not including them in draft contract as decision makers in certain future decisions. And so when I'm referring to, that, I think, there's kind of a, I'm kind of referring to like the Indiana Code 36-110-7 in county council's duty regarding to that. There's kind of an implicit, but I didn't explicitly say that, I think, in Indiana, and refer to Indiana Code 36-110-7 in there. So, yeah.
Yeah, I mean, I appreciate the citations in Indiana code. I mean, but
Yeah.
I don't think it's necessary to
Mhm.
just know that, and that goes for
Mhm.
everybody. I mean, we're trying to just take information for
Mhm.
why you think that the lease is unnecessary and unwise. If you
Mhm.
want to cite if you think that helps bolster your argument, great. Not opposed to it. Just know that it's not necessary. It's an administrative proceeding. This is not
There's no expectation.
no expectation of legal argumentation. Sorry, it's been a long day.
Mhm.
So, I think that's all I have for you, Mr. Fernandez. Thank you. Actually, just want clarification, and this has to do with the order in which I'm being asked to call up people. You're representing Help Not Handcuffs. Is that correct?
Me,
Or you're in your own capacity?
I'm representing myself individually, even though I
Okay.
mentioned those groups in my in the petition, and those groups, individuals from those groups have signed on to the petition. So,
Okay.
as well. So,
Okay. And the reason why I ask again is you instructed to go first. Then Tina Hughes followed up saying that the Allen County Residents Against the Jail group would like to go after people from Help Not Handcuffs. Just want to make sure I'm not missing anybody because I was going to go to them next. So, okay. So with that, thank you, Mr. Fernandez. I'll go
Yes.
ahead and please put yourself back on mute.
Yes, I will.
Next will be Tina Hughes. Also, I want to make sure too, is there anybody here who is, especially if you're in like a group, if you're in like a public building that is going to be closing in the next 15, 30 half-hour minutes, if you're wanting to speak, I want to make sure you have the ability to speak as well. So, because we've had this happen before in prior hearings where people wanted to speak and had to get the building was closing that they were in, so just want to make sure. Otherwise, Ms. Hughes, please go right ahead.
Hi. I'm gonna try to remove this echo.
Okay.
Go ahead.
Hi, my name is Tina Hughes, Thank you for granting this hearing.
Sorry.
Just one moment, see if it's working.
Let's just leave. We'll just,
Okay,
Yes,
is that better?
Okay,
yes, because if more than one person in the same
Yeah,
room is
yeah,
signed in
feedback.
with that, you'll get the feedback,
yeah,
so.
so
I'm not sure.
They can hear you. Go ahead and
Okay,
do that now.
I can hear you.
Can everybody
I can
hear
you
me?
fine. Yes.
Yep, there's no
Okay.
echo.
all right. So my name is Tina Hughes, and thank you very much for granting this hearing. I would like to request that we have an actual in-person hearing so that it is fair to all the Allen County residents that were not able to attend this hearing virtually due to the time constraints with the holidays and/or the technical difficulties of having to speak virtually. Having only 5 days notice during the holidays and then you take an additional information up to January 18th could have allowed for a little more time for us and others to prepare to speak on this very important subject. But thank you for having the hearing. I am a resident of Allen County, and I am speaking on behalf of hundreds of the residents that live within a half a mile from the proposed jail site. We oppose the lease contract for the courthouse and/or the future new jail. It is not necessary. It is a waste of taxpayer funds. Our commissioners are borrowing against our county courthouse and future jail for the next 20 years in order to circumvent the normal legal limit in the county budget that they can borrow against. This clearly overburdens the taxpayers of Allen County even further than the original income tax. Reasons for opposition of the lease. 1. This lease removes the county council's ability to safeguard against wasteful spending in the future. It takes them out of all future decisions, and our county council vetoed funding this largest project in Allen County history the first time, and then almost vetoed it a second time, only passing it by a slim 1 extra vote when the tax amount was finally lowered. That is what our county council was elected to do. We believe it is the taxpayers' right to have our duly elected county council involved in the decisions concerning this lease now and in the future. The terms of the lease are too vague. There are no restrictions or limitations where there should or could be some. 2. It is an excessive, unnecessary taxation of Allen County residents at a time when people are struggling and foreclosing on their homes. Following is why we believe it is unnecessary. There has never been an independent study done on the current jail location to evaluate the feasibility of using the current jail buildings and surrounding spaces in the future and adding on to them. Instead, they are imposing a hefty income tax and borrowing against our courthouse for the next 20 years to build a new jail next to 220 residential homes and a park. Our county council made several requests to the commissioners that they order an independent study be done by a contractor that doesn't give or receive campaign contributions to either side, and that they had found such a company for $200,000. The commissioners refused. Instead, they chose the most expensive company to do a study that proved why we needed to build a jail. Other options were not explored. And then they awarded the project to the same highest bidding engineering company that did the study. Our county council tried to do their job and stop this overreach, but the ACLU informed the county council that they could be sued if they didn't approve a plan. So the community came up with an alternative plan that would allow us to use the current jail buildings and expand onto them. That plan would save approximately $200 million, be built in less time since we had the blueprints done and work already started, and create the same number of beds and even create a mental ill health annex. And the community plan does not need to borrow against our courthouse for the next 20 years. This is why we believe the terms of this lease are unacceptable to the taxpayers. The community held a town hall and invited the county judges, commissioners, and county council, and only 2 county councilmen came to hear about the plan and see it visually. They engaged with us and the community. They spoke and they took questions, which is what the commissioners should have done in the very beginning of this process. Again, this lease is not needed, it's not necessary. It is a waste of taxpayer funds. This is why the Allen County residents no longer trust the judgment of the commissioners in the matter of this long-term lease without oversight of county council and a second opinion from DLGF. Our tax burden just keeps growing. Our mortgage exemption was taken away. Our property assessed values have doubled and tripled in the last 2 to 3 years, raising our tax bills before the cost of the jail is even added. And if the income tax and or the lease fail to raise enough funds, of course, the backup fail-safe plan is to be paid by our property taxes again. Where does the taxation end? What is the constitutional limit? Southeast Fort Wayne is the most impoverished area of the county and was legally declared an environmental justice area in 2021. And although nearby businesses may get an economic boost from the new jail, the 256 homes immediately adjacent to this facility will statistically lose an average of approximately $12,000 of equity in their homes that are already highly taxed. Allen County residents are starting to question the judgment and decision-making of the commissioners concerning the lease and the jail. The county auditor reported that the county only had $27,000 left in the general fund near the end of 2023. With a budget as large as Allen County, it is unthinkable that they would let funds get that low in the pursuit of building the new jail. They are desperate to move the jail from the riverfront area. In the comprehensive plans of 2015, they said, once the jail has been moved to another location, we suggest the buildings be used as rental housing units. This is in writing. You can see it. It's online. So if the jail buildings can be fixed for rental housing units, they can be fixed for a jail. We restored the electric work buildings, and that worked great. We could restore this jail right where it sits. So please, consider the vague terms and lack of oversight in this lease and the excess, unnecessary tax burden for the Allen County residents too. We would like to ask for the independent study. Again, we'd like to ask for the independent study to be done and save the approximate $200 million and keep the jail downtown where the people need it and cancel this lease that leverages our county courthouse when there are other options to consider. Thank you for your time and consideration.
Moment. Thank you, Ms. Hughes. You mentioned alternative funding available online. Or is that available? Sorry. Okay. Okay, so, oh, Mr. Fernandez, can you,
Sorry. No. Oh, I'm
looks like you're signaling you want
sorry.
to speak.
Sorry.
Yeah. All right, well, I guess we'll.
Miss Hughes signed back on, so I don't know if she'll be able to answer your question now.
Okay. All I really want to know is that the alternative plan that was mentioned, is that something that is like in writing or available that we can see?
Miss Hughes, you're currently muted.
If it is, if you can please send it to us. That's pretty much all I'm asking for. If you have that plan available that we can see it.
Okay, can you hear me?
Yes, we can.
Yes.
Okay. Yes, I can send a copy of the plan to you, and Every department, the commissioners, the county council, the judge, has had a copy of this since
Mhm.
October something. So definitely can
Mhm.
send all of that information to you.
Okay, thank you.
You're welcome.
Thank you. I don't have any further questions for you. Thank you for speaking and being here. Next is Amanda Scheitman.
And Amanda, you'll have to unmute yourself.
Can you hear me now?
I can
Yes,
hear
we
you,
can.
yes.
Oh, I didn't hear.
Oh, sorry. Yes, we can hear you.
An objection, obviously.
Mhm.
Okay. Allen County did not consider the environmental impact of a jail in violation of the Federal National Environmental Policy Act, also known as NEPA. The use of federal money to construct a jail should be subject to NEPA. The commissioners knowingly, recklessly chose a designated Environmental Justice Act area to build the jail. Out of 657.30 square miles of Allen County, they chose the single most overburdened, impoverished area of the county. ARPA money is federal money, and it is in violation to use it to build a jail through the Environmental Policy Act. That's it.
Okay, thank you. Next is Ann Cornwell.
You won't get the reverb.
I don't see an individual named Ann Cornwell that has signed on electronically.
It might be.
If you're one of the call-in users and you are Ann Cornwell, you'll need to also unmute yourself.
Ann is here. Sorry, we're having some technical
That's what
challenges.
okay.
Hi, my name is, we vibrating. My name is Ann Cornwell. I am a resident of Sunnymead Edition. I have lived there for 35 years. In my opinion, it is very negligent of them and unfair, first of all, because of what Amanda had just mentioned about the poverty level. There are extreme water issues in the whole area. The particular plot that they are going to plan to build this jail on is it's a swampy area. My yard doesn't look like a swamp, but there are water issues in the whole area. None of this has been investigated. And once their money was approved, the first thing they came up with, there's going to be a delay because of the water issues, wetlands. So that's just what I got. It's not smart to build a property like that and with that much money involved in a swamp. And pretty much that's what it is.
Okay.
We deal with water issues in Sunnymead all the time. My driveway, I replaced about 15 years ago. I have a crack that is an inch wide, one side. That crack has dropped an inch, and the only thing I can do is dig it out and redo it. This just is not a smart place to build any building, let alone a facility that big and at that expense is just negligent. And to the best of my knowledge, they have not had their delineation report done as of when we spoke to Evan White last week, who is with the EPA. So thank you for your time. It's just a dumb thing to do. It's not responsible.
All right, thank you, Ms. Cornwell. Next I have is Alice Lupke. You are on. Yeah, I see her right there. I see she's separate. Ms. Lipke, if you can unmute. You're ready.
She on?
I can hear very, very faintly, but I can hear you.
Anybody else who needs to speak should use this one, and I'll turn this off. So that we don't get that.
Okay.
So it looks like Ms. Lipke is signed in independently. So if is she in the room with Mr. Ortiz or?
No, she's not in the room with us.
Well, what we'll do, she was the last person I had signed up. But I will. Wait, hold on. Hold on. What's the chat?
We do have Abby Norton
Yeah.
that said they signed up.
Abby Norton. Okay. Okay,
Okay.
go ahead.
So I just want to preface that I agree with everything that everybody said here. I think
Mhm.
everybody has valid points. And if we have more time, I'd love to hear more of what Jorge has to say because I just really enjoy the way he has laid this out for us all to express ourselves, starting with the obvious that it seems like something's just not going on correctly here. Especially when we talk about the environmental impacts. For the commissioners to say that they had no idea that there were environmental impacts is just factually incorrect. I have with me my notes from every single meeting that I went to object this. And I myself personally have brought up environmental impacts going back to 2022. So for them to say that they don't have it is a lie. They have been warned multiple times by the public that what they're doing is going to harm the environment and it's not going to be good for us. And I specifically began when I began fighting against the jail with the environmental racism that is happening with putting this in the southeast side of Fort Wayne or southeast side of the county with everything else that's already there. So the commissioners have been duly warned multiple times. I myself have a handful of times, and you can go back and review public record. Every commissioner's meeting is recorded, so you can actually review every single comment from every single one of us who have already been up to like publicly on record explaining environmental issues and explaining why what they're doing isn't to the benefit of the community. And I would like to add also that I went to several of the federal court hearings. The judge specifically said multiple times in multiple different hearings that he is not and cannot order the county to build a jail. So again, that is the federal judge specifically saying he's not ordering the county to build a jail. So for the commissioners to continue to operate as if the judge is making them do this, again, isn't accurate and seems to be quite misleading to the public for anyone who isn't sitting in the courtroom. And then I feel like I had another thing, but I kind of, oh, the ARPA funds. So I'm not sure if you're, I'm assuming you're familiar with ARPA, the American Rescue Plan Act. So it's my understanding that some of these ARPA funds are going to be used for this jail project. And I cannot find any valid reason to use COVID relief funds to build a jail 5 years down the road. That has nothing to do with COVID. It has nothing to do with helping American families or businesses. It does, in my opinion, continue to be abused by this commission. It doesn't seem to be in the benefit of us. And so I would just like to add that as with everything else, the funding isn't there. They were warned multiple times before they passed for the little bit of funding that they got, and they've immediately ran into the issue that we've been talking about for over 2 years now. So it's a misuse of fund, and it feels like taxation without representation when I've been to meetings and there's been lines of people speaking out against this, asking for transparency, asking for budgets and plans, and how is this going to actually help us? And it all comes down to there are people right now as we speak who are having their human rights violated by our jail. The commissioners have been ordered to stop that. And instead, they are trying to force us to pay for something that isn't going to fix anything for years down the road. So in my opinion, they are doing all of this knowing willfully that the more they push for this, the more people are going to suffer in our jail. And this is not like, I think it fails to resonate with people. Human rights violations in American jails. Like, that should not be happening anywhere in the world, let alone our own county jail. And when our government officials are intentionally blocking any way forward to actually help these people, what they are doing publicly is saying they are fine with our residents having their human rights violated. The county commissioners are saying it is okay that there are people right now spending the night in jail, not getting their basic human rights met. Any plan for a new jail does not stop somebody today from getting their rights violated. So this is a misuse of funds. This is not necessary. And all it is doing is creating chaos so that the jail can continue violating human rights. And this needs to stop by all means necessary. These are human beings. They deserve their human rights. Most of these people have mental health issues. I mean, that's also in the public records that we've been talking about since 2021 or 2022. So the more we push this off and the more we allow them to misuse our funds and tax us without representation and put us in cages, the more we're saying that we don't care that our community is violating human rights and that our community members are getting their rights violated. Because any single one of us could get pulled over for something and get arrested if the cop's in a bad mood. So we need to get this under control as a community, as a government. We should not allow human rights to be violated. And it's shameful that it took the federal government to even say this is an issue. And now we are years later and the issue hasn't stopped. The county's gotten more money and they're still violating human rights. That is all I have to say.
Okay. Thank you, Abby.
Yep.
I apologize. I think I missed a couple of other people. And if Ellis Lipke, if you're still on, I will call on you. But I also have Amber Oda and Howard Traxmore. If you're still here, we can double make sure. Haven't missed anyone else.
Alice Lipke did just rejoin and then she just left, so
Okay.
might come back.
I see Howard Traxmore. He waves at the camera. Oh, sorry. Under Tina Hughes, are you Alice Lipke? Okay.
I'm Amber Oda.
Okay, Amber Oda, and then I'll get to Howard next. Amber.
Okay, thank you very much for this opportunity to be able to speak today. I just wanted to add my voice to everyone else who is here and just state that I'm in agreement with all of the points that have been made. I do not believe that this project is needed, nor will it be a benefit to Allen County, nor have county commissioners' decision-making process been diligent, nor communication from commissioners been transparent to the public. Since 1970, Indiana's jail incarceration rate has increased by 526%, according to the Vera Institute, despite the average crime rate in Indiana of about 19 crimes per 1,000 residents, which is significantly lower than the national average. Therefore, when the county states that we need a larger jail for our increasing criminal and violent population, they are effectively ignoring the facts. They are also ignoring the fact that the county has benefited in the past from leasing jail beds to house people for Indiana Department of Corrections, which earned the county nearly $2 million in 2019 alone. So this gets to Jorge's point earlier. Allen County Commissioners hired Elevadis architecture firm to conduct an assessment of the current jail and then hired the same architecture firm to design a new jail, which seems like a direct conflict of interest to me. Elevadis still offered county commissioners other options besides building a new jail, and one of those options would be to expand the current jail, which Tina Hughes elaborately laid out that possibility for us today. The possibility of renovating the 4th floor and adding 2 additional floors, according to Elevadis, would cost an estimated $21 to $23 million and increase the number of beds by 236. But again, it seems obvious to me why the architecture firm that conducted this analysis would ultimately advocate for the highest spending project, a new massive jail, especially if they were in line to be the chosen bid for the actual project. If researched and considered more in-depthly, renovating and expanding the current jail would potentially address Judge Liechty's concerns about the conditions of the jail, which, by the way, waiting 3 to 5 years for a new jail does not adequately address the original lawsuit about overcrowding and understaffing of the current jail. Renovating and expanding the current jail would not overburden Allen County taxpayers, many of whom are already overburdened, with an unnecessary and long-term spending project, the largest public spending endeavor in Allen County history. This project is an absolute waste of taxpayers' money and does not adequately address the root causes of crime and is not needed. Rather, investments in education, affordable housing, mental health and addiction treatment services, and trauma healing programs outside of jail and the criminal legal system, and so many other community-based programs well deserving of our taxpayer contributions. Thank you very much.
All right. Thank you, Amber. Okay, Howard Traxmore.
Thank you. I would like to discuss the complex financing that has been proposed in the lease and how it goes one step beyond the court order, and therefore I believe a public petition should be allowed, as the Indiana Constitution on financing provides. The existing jail should be able to be fixed without the petition, but if the plan is to go beyond the current jail, then I think that should require the right to public petition. The mixing of property tax and income tax and other sources into one plan, I believe provides a level of complexity that the Indiana public finance law is a little bit behind on that as far as these type of projects. And so I agree with the points that Jorge and Tina made regarding the issues and alternatives. Now, when the lease proposes a point at which a traditional bonding would take over, I think there needs to be a clarification on how that occurs. I think the way that the county council has been kind of moved to the side and left out of its due diligence to really look at alternatives is a problem for basic public financing credibility. When the lawyers for the county said that the economy looked to be stable enough for this plan, they didn't really present evidence for that seemed to be credible. And I have reviewed the economic forecast, including from our own government, and the forecast is very likely for a recession in the near term. And, you know, the breaking point on where that falls and how far the reserve fund would go in case of a recession is all very unclear. And I think public finance law needs to be clarified on how that should work. And given that the lease does not really cover that very well, I think the department should not allow this to go through. So thank you very much.
Okay, thank you, Mr. Traxmore. Let's see. Is Alice Lipke still want to give her a chance to speak if she's still on? Otherwise, we may have to move on to the county. Almost going to double check, make sure there's no one else. Else.
I do not see
Okay.
Alice still signed in.
Okay. In that case, then we'll move on to the hearing from the county, Mark Cranley from Barnes and Thornburg indicated that he was going to speak. And then there were a couple of others. Laura Masser, county attorney, and Chris Cloud, the deputy auditor. But my understanding is that they're only if needed. So in that case, Mark Cranley, if you are on.
I am on and I'm unmuted and ready to go.
Okay. When you're ready.
I want to start with focusing on what we're really here for today, which is to determine whether the specific lease is unnecessary or unwise. And we've kind of discussed a lot of different things today. I submit that we followed all processes and open door notice issues, including for the building corp, which meetings we agree are covered by APRA. And APRA notices were given for that meeting. And so we're not wanting to focus on every last thing that was said, because some of those things are either off the table as far as what we're really here to talk about. We will be following up with the documents I'll be referring to today. I think a lot of them are already in front of the DLGF, but we want to make sure you've gotten them. We did not do so yet out of abundance of caution, because additional things do come up in these types of hearings, and we want to make sure we get everything to you in one clump. I guess the way I would like to do this is to first talk about the necessity and how we got here and what the timeline is. As we all know, this is a jail project. It is not the type of thing any municipality wants to do. It's a necessity, and the commissioners have an obligation under Indiana law to provide a jail. They have a statutory duty to establish a jail for the sheriff to operate. This jail that we're talking about in Allen County is 43 years old. It was first opened in 1981 with additions completed in 94, 98, 2004. That's a long time ago. The building is a heavily used public facility. This is a 24/7 nonstop use over a period of 43 years. This obviously takes a lot of toll on things like plumbing, electrical, mechanical systems. No doubt the sheriff and others have done a diligent job in maintaining the structure, but it's a very old structure for what it does. Jail currently has 732 beds, but the jail population for the last several years has been in the upper 700s and even into the 900s. It's obviously inadequate. There's simply not enough beds to accommodate the numbers of people being sentenced to and being held in jail. I know we've had some conversations today about there shouldn't be so many people in jail, and there's a philosophical debate to be had about that, but the county commissioners are just not in that position. We have to provide a jail to meet the current conditions, and that's particularly so when we're facing the federal lawsuit that hangs over all of this. I mean, obviously, the situation is not optimal as it is for 732 bed jail, when the rule of thumb is that 80% of the jail is occupancy, not every bed filled, but you're considered at occupancy in the for lack of a better term, the industry for the jail industry, if you're at 80%, which would only be 586 beds. So the federal court, Judge Liechty, and will provide the court's order, handed down an order in March 31st of 2022, saying that the current conditions in the jail violate the federal constitution. It's something we take very seriously. The commissioners want to address this. In fact, we're under a federal court order to address this. The argument was made, well, the federal judge never said you had to go out and build a jail, and that is true. The federal judge said he didn't have the power to do that. But he did require us to remediate this situation, to provide reports on our plan. It gave instructions as to what a new jail that would satisfy the order would look like. But here's some of the findings that the court made about the existence of the jail. The court finds that the jail's physical structure precludes the jail expanding on its current site to a size that will remedy its endemic overcrowding and the harms flowing from that overcrowding. The existing physical structure of the Allen County Jail prevents the Allen County Sheriff from discharging his duty to care properly for the prisoners housed there. Those are findings a federal judge has made against the county that the county has to react to. commissioners, obviously took action on this. We've conducted a public hearing under the statute. We've retained the Elevatus architecture firm to review these issues. I know there's an argument made that somehow this is an unfair situation where they have made political contributions to I don't know who. I'm assuming that's correct, or perhaps the firm did, but there's no reason to doubt these gentlemen and ladies and gentlemen that worked on this project, their neutrality, their ability to work professional. These are professional licensed architectural professionals. I don't think there's any reason to doubt what they did. The county went out and hired a financial counselor, hired bond counsel, made a full-scale review of what needed to be done to address the jail issue. I think it's beyond, given the nature of the situation with the federal court order requiring the county to take action to remedy the jail, the idea that this lease would somehow be unnecessary is really unsustainable. The question, I'm sorry, unnecessary. So let's look at on whys. I mean, that's why we hire Elevatus to make a thorough examination, and we'll provide both the report and their PowerPoint slides that they presented to the commissioners, kind of going over that report. They, as I think is wise and the right thing to do, they didn't just offer what's the solution for right now, but what are we going to look like 20 years from now? And if we're going to spend public funds, let's look for solutions that are appropriate for the future as well. So they did some projections as to what the jail population might look like going into the 2040s. They did this several different ways. They compared what the current jail population is versus the entire population of Allen County. They did some forecasting based on trends. They did some statistical analyses and essentially came up with what can we expect. And the ultimate recommendation was you need to be thinking about a facility that has 1,500 beds. Otherwise, you're going to be in a position where we're right back in the briar patch we're in, where we're looking at federal court litigation, we're looking at inhumane conditions, and we don't want to be that. We want to fix this problem. If we're spending county money, we want to make it right. So they looked at several options. The first option that they proposed is one we've already talked about today. Why don't we just vertically expand the jail? We can't horizontally expand. There's nowhere to go. This is in downtown Fort Wayne. The only possible property we could move to is a public park, and I don't think that's a feasible option. And Elevatus said it was not really a feasible option. So we have to go. We can't go outward, so we have to go upwards. And it is possible to put additional floors onto this building. But what's not been really discussed is how little bang for the buck, for lack of a better term, the county would get through that option. We would be talking about adding 200 and some beds to get us to 977 beds. That number would have us at an insufficient amount within a matter of years. If you look at page 15, when we provide the Elevatus study, they say by 2025, we would have a need of 1,007 beds. And so building up, as expensive as that would be, is going to have us overcrowded again within a very short number of years. Another option looked at was the possibility of a regional jail or entering into contracts with neighboring county jails. Their studies showed that there was very little interest in that from any of the adjoining counties. We obviously can't force them to enter into a contract with us. If they're not interested, they're not interested. And the ones that were interested didn't have significant enough space to make a difference, and they would be prohibitively expensive, even before we got into the cost of it was $120 million over the life of over this project, and that's even without the transportation expenses that would be incurred by taking people from county to our county. So the third option was, well, we need a new jail. Let's look at a new jail at a new site, which is where we're at today. I'm going to switch gears now into answering some of the concerns that have been raised about that option and what what the appropriateness of the option chosen. The first I want to address is sort of the issues with the property tax backup. Mr. Fernandez referenced the idea that this isn't a controlled project. From his opinion, it's not a controlled project, but that's false. Under Indiana Code 6-1.1-20-3.2, there's a limited amount of remonstrance available for on the property tax issue, and that's only for controlled projects. That's defined in 6-1.1-20-1. That includes a project that is in response to a court order holding that a federal law has been violated. If I was going to sit down and write a statute that applies to our situation, that's the language I would use. This project is obviously and patently a response to the federal court order finding that there was violations. So clearly we're not a controlled project. But where did we get there? Secondly, too, which is section A1 of that statute, which says that a project, it's not a controlled project if the project reasonably expects to pay debt service or lease rentals from funds other than property taxes. Now, the argument here is that as a last resort in the lease, there could be a situation where property taxes are used. But in our financial projections, Baker and Tilly has looked at this and provided these in meetings, even under the 0.11 lit rate that's been approved by the county council for this project, and said it's unlikely that property taxes would ever be used. I guess the next one that has come up several times is the role of the county council. This isn't stripping the county council of any powers it has. We have a bifurcated county government. County commissioners have their roles, council has its roles. As has already been indicated to you, the county council passed a resolution approving this lease. It's also approved the lit tax rate that's being used to pay for lease payments. So they have carried out their statutory duties. The lease is a matter of public record. It's been discussed, and it can be discussed at future meetings. Nothing prevents that from happening at either the commissioners or the council. But the council has the role of providing the jail. That's what we've gone out and done. And that by doing so, that doesn't undermine the powers of the county council, particularly when the county council has approved it. Essentially, the way I understand this county council argument is that, well, they've approved it at one time in history, but what about in the future? But that's the very nature of a lease. I mean, when a county council approves a lease, it anticipates that lease is going to be in place and stretch over a number of years and apply in those years. So I mean, I think that's just part of the process. Let's go to the next one, the environmental arguments. I understand people's environmental concerns. I understand the idea of a wetland. But that's not what we're here to discuss today. There's permitting for those issues. There's review of those issues by the environmental agencies. That simply doesn't apply to what we're here talking about today. It's an issue for a different day. The idea of the building corporation and the timing of the building corporation, it's been well settled for years that the building corporation can be created after the lease is approved, let alone before, like was done here. We certainly agree that the building corporation is an agency subject to APRA, but that doesn't change its ability to be created and the awareness of the public and the council of the building corporation. As far as the use of the building corporation as an entity paying the lease, I mean, I guess I'm kind of drifting into the constitutional debt limit issue here. There is no debt here. This is a lease. We're not making debt payments. If the property under which we're leasing would suddenly become unavailable to us, the lease would terminate by its clear terms. But even more important to that, I think, the idea that we're trying to slip one over the transom on the DLGF by having a building corporation, I think the day for that is long settled. It's a commonly used way of municipal finance, and we're not doing anything. We're not reinventing the wheel here by using the building corporation as a means to lease these properties and make payments under that lease. There was a reference, I believe it was Mr. Fernandez, to the idea that, well, you could use this for federal inmates, and why are we paying on this lease if federal inmates are going to be housed? There haven't been federal inmates housed in the Allen County Jail since June 15th of 2022. The contract with the federal government's been terminated. The overcrowding numbers we have are not as a result of federal inmates. They are Allen County based inmates. So I just don't think factually there's much of a concern there. Again, it's not it's not an issue that's currently affecting the jail. I'm just looking through my notes on some of the other comments that were made. But I don't think I have any other points at this time, but I would welcome any questions you may have.
Okay. Thank you, Mr. Cranley. You said you were going to provide some follow-up information. Can you please list off what?
Yep.
If you know.
I'm opening up my folder now that has all the documents in it. We will provide the federal court order. We have 2 Baker Tilly studies for you. One that was done in 2021 and one that was done in October of 2023. These will show the anticipated revenues from the lit that was including at its current level that was set by the county council. We'll provide the county council resolution. I believe you talked with Mr. Fernandez about this earlier, but we'll provide it as well. We also have the Elevata study that was presented as public documents, been discussed in public meetings, as well as the slides that they prepared to explain that study in the public meetings with the commissioners.
Okay.
That's at a bare minimum what we'll provide and what I was referring to here. But
okay. Thank you. The 2 other things I brought it up at the beginning. Was there a notice of public hearing and notice of determination published regarding the lease?
Yep, we can provide this as well.
Please, yes. Want to make sure we got the procedural stuff nailed down. You mentioned in your comments about using the property tax as the backup. I guess my one question about it is when the lease was being drafted. Actually, let me back up. Is there another version of the lease? Because this is going to be some questions I'm going to be asking either you or if someone else from the county is able to provide it. There seemed to be some. I'm not quite sure exactly if there's, for example, an amortization schedule. I wasn't able to find it in what was provided by the county auditor. But so I'll ask if there was an updated version of the lease. But when this lease that was executed was being drafted, did Baker Tilly conclude before then that the jail lit revenue would be sufficient?
Yeah, I suppose I should have been more accurate with that. Yes, the answer to that is yes. And then they did the second study we're going to provide that adjusted that based on the lower lift that was provided. We will provide both of those.
Okay.
And I will make sure you have the signed copy of the lease, the fully executed copy of the lease as well, with all attachments.
Okay, thank you. And I guess my follow-up question to your response is, then if your financial advisor is confident that there would be no need for property tax, then why reference it in the lease?
I think that's a prudent safety net that most leases of this type will have, because again, we are dealing with projections. We're dealing with a well-respected, renowned agency in Baker Tilly who knows how to do these things, but one never knows.
Right. So, but it appears the county's position is that the jail lit revenue would be it'd be sufficient enough to where there wouldn't be a property tax, use of any property tax levy at all
Correct.
with this project, okay. And then staying on the topic of the lease, I see, Exhibit A describes the real estate description. 3003 Meyer Road, Fort Wayne, Indiana. Assume that's kind of the Sunnymead area. And I guess this will be related to the Elevatus report, or will be Exhibit B, addendum to the lease. Annual rental set forth in Appendix 1. That's the other question I had with respect to the lease itself. And I assume this will be provided in the updated document, but do you have knowledge, or somebody else from the county can answer if available, what the expected lease rental is, what the annual expected lease rental is going to be?
I don't know that question, but I would ask Mr. Cloud or Ms. Mazer to answer that if possible.
Okay. I will. Yeah, I will be sure to do that. They'll see. Got that one. You referenced that it's established that a building corporation can be created if the lease is executed. Can you provide a statute citation or case, a court case that that states that?
Not off the top of my head. My memory is not quite that good, but I will provide that in our submission.
Okay. And then along the same lines, comment that the lease is not considered debt for purposes of the constitutional debt limit. Is there, if you can provide a statute or a case supporting that contention as well, that will be helpful to us. I'm trying to think if there's some other comments or questions I have for you. Sorry, having a sidebar. Sorry,
Okay.
we're having a sidebar. Has there been any comments from like local zoning agencies or like a state agency like IDEM, or I know an earlier testifier mentioned the EPA. Has there been any expressed comments or concerns regarding this project from those entities?
Not that I'm aware of, but I would ask Ms. Mazer or Mr. Cloud to respond if they are too.
Okay. All right. Okay. That's all for you, Mr. Cranley. Thank you.
Thank you. Appreciate your time today.
Certainly. So Laura Maester, you're available?
Yes, I am available, and I think I'm unmuted.
Yes, I can hear you.
I don't have additional comments other than what Mr. Cranley made, other than that I will attempt to address some of your questions. You had asked if there's another version of the lease, and our bond counsel has prepared the lease and taken care of that. We can confirm with bond counsel whether there is something else floating around out there, but I'm not presently aware of it as I sit here today. But when we submit our additional information and our documentation, we can cover that. With respect to expected lease rental calculations, that's something that our financial consultants prepared, and I don't know if they're on the call or not at this point, but we could also supply that to you, or if Emma Adler is is still on the phone or on the call from Baker and Tilly. She might be able to jump in if the DLGF would like to hear from her and if she's present. I can't see whether she's still presently on the call or not. But we can definitely provide the calculations for the DLGF. And
Laura?
yes.
This is Jason Simler from Baker Tilly. Emma had to jump off, but I'm here as well as a partner here at Baker Tilly, serving as the county's financial advisor. And we definitely do have estimates that we can provide.
Yes.
If I could, you'd have a question about the property tax as a backup, and if we're showing that there's sufficient revenue to cover the anticipated lease rental payments, why do you need the property tax as an additional security? I'd be happy to answer that if you'd like me to.
I mean, if Ms. Macer defers, I'll let you answer.
Yes, please.
And that is very common for projects like this, as using the property tax just as a marketing tool, as a backup, because as we're looking at issuing bonds to fund this project, the ultimate source is going to be the local income tax of the county. But from a bond purchaser's perspective, property taxes are a more secure revenue stream. So we often do it kind of like a double barrel, provide the security for the bonds to be multiple revenue resources. The local income tax is what we fully intend to use, but then have a property tax backup just to provide bond purchasers just that additional security to allow the county to get the lowest interest rate on the bonds possible, to make the overall financing cheaper for the county.
Okay, is that an industry practice?
Yes.
Okay. All right, thank you, Jason. Ms. Macer?
I was going to say the last question that I think I heard from the DLGF that we may be able to answer is whether IDEM or EPA have chimed in on environmental issues or concerns. And in the building process, there are a number of permits, a number of things that have to be done. And yes, wetlands and environmental concerns are taken into consideration. Presently, my understanding is that there are some small areas of wetlands that have been delineated on the property, and that both the Army Corps of Engineers, which is a federal entity, and the Indiana Department of Environmental Management are looking at those and determining which entity or agency may have jurisdiction over the various areas of potential wetlands. And once that determination is made as to jurisdiction, then we will learn what we need to do in order to obtain the proper permits to proceed. So yes, perhaps there are wetlands. It's not unusual to have areas of wetlands or other environmental concerns in a project of this nature. And the county is working through the process to do what is necessary to proceed and to protect as necessary the environment.
Okay, have they provided anything to the county in writing? Or is that still under investigation?
Like I said, to my knowledge, we're in a process of those agencies determining which has jurisdiction over the areas that may be wetlands. And I don't know that we have a report or any kind of documentation regarding a decision on that. I have not seen that to date.
Okay, to your knowledge then, if somebody else needs to speak to this from the county, if it turns out there is wetlands, what will be the impact with respect to the lease and the project that is covering?
I mean, if there are wetlands, we will go through the permitting process regarding how to deal with those. We have environmental experts who are retained to guide us through that process. we don't anticipate that any areas of concern will derail the project or cause us to need to stop work on the project. However, we may have to take regulatory precautions as determined to proceed.
Is it then possible, is it possible that any of the expected costs, like the maximum cost of the lease, would have to be adjusted in light of those permits or those changes?
I don't know the answer to that. I would hazard to say no, that we're
Okay.
not looking at areas of concern that are so large that it would impact the lease or this project. But I am not an environmental expert and we don't have reports. I cannot guarantee that therefore, but no, I would not anticipate that the cost would affect the ability to proceed with the lease or the project.
Okay, and the county, well, they're engaged with the IDEM and the Corps of Engineers, not any other entity related to the environmental issues?
Not to my knowledge.
Okay. Okay.
Hello? I would like to make a comment about the wetlands if I could.
Ms. Hughes, I'll let you speak before, I don't have anything else from Ms. Messer. Thank you. I'll let you speak, Ms. Hughes, and then I'll see if Mr. Cloud has anything to add, but yeah, go ahead.
Okay. The FEMA maps do show 3 legal wetlands, and the county had mentioned a couple of weeks ago that the wetlands are a cause of delay at this time. And we have been in contact with the EPA and IDEM as of a year ago, and they are requiring a delineation report to be done. The county understands that, and they are working towards that. But it's still not clear if the delineation report has been done. So if they could clarify that, that would be great.
They being the county?
Yes.
Okay. All right, is that
Chris,
it?
are you able to clarify that?
Sure.
Okay, thank you,
A
Ms. Hughes.
draft-
Sorry. Ms. Hughes, do you have anything else to say?
No.
Okay, thank you. Chris, go ahead.
Yeah, a draft wetland delineation report was submitted to IDEM and the Army Corps of Engineer. What they are doing is a process called jurisdictional determination, JD, and that determines who you go through for permitting. If the Army Corps determines that a certain type of wetland is present, then they maintain control under the federal EPA. If they find that these are what are called isolated wetlands, then IDEM is the appropriate permitting agency. So wetlands did not delay anything. They are still working on determination of who the appropriate permitting agency will be. Any wetlands that were on the draft report were already incorporated into the site development plans that were prepared by our architect and engineer team that are involved in this. Anytime you do massive site development of any unimproved site, this was a former farm field, that requires all sorts of drainage plans and other water, hydraulic plans. All that was part of the engineering studies that were done by the engineering team, which is headed up by Engineering Resource ERI on the project. They're one of the sub-consultants to Elevatus on this. When the EPA or when Army Corps and IDEM are satisfied about who has that authority, then you can finalize your wetland delineation report. But they are the ones who ask for amendments to it, adjustments to it, as they do that evaluation process. So that is in process. What we were told was because of the end of the year holidays between Thanksgiving and Christmas, that takes a little bit of time due to vacations. But we were assured that the local Army Corps office, which I believe is up in Detroit, was working actively on making that jurisdictional determination.
Chris, did they give any, said they're working on it. Did they give any time, like like a date when they're planning on finishing it, or is it?
We actually expected to hear about the termination near the end of the year. So I would assume that that'll be a forthcoming thing in January. That's what there's a wetland consultant that ERI uses to do the wetland reports. And so that person is the one who's interfacing directly with Army Corps and has been for months, and also IDEM. And so it's sort of a best guess. They have statutory limitations on how long they can take to review these things and respond. And as you can imagine, in the regulatory process, they give themselves lots of time. So there's no expectations they take all that time, but they have time. So we were not expecting to have answers back until the January timeframe. So the fact that we were told maybe end of the year was ahead of where ERI thought we might be on that process.
Okay. Okay.
To the point you brought up though about if a determination is made by Army Corps or IDEM about wetland issues, will it impact the lease or the cost of the project? As I mentioned, the wetlands that were known in the delineation report, which I would call a near final draft. It's not final until EPA says it's final, but a near final draft were incorporated into the site development plans and the drainage plans for the area. So the associated costs would have already been calculated into the budget figure. In addition, there's a contingency for the project like there is for any large project. So it is not anticipated that what may be added to the delineation report would be of a dollar amount that would cause any concern to the budget. In addition, when you encountering wetlands is a common occurrence. We do road work throughout Allen County. It is a common occurrence in an area that used to be a swamp a long time ago. And so wetlands and dealing with wetlands is a common occurrence for us. It is a heavily permitted and regulated area. You have to follow all the appropriate guidelines. So we are working with the professional licensed state engineers and qualified individuals to work through the federally and state regulated processes. You can't wing it. It's a prescribed process. So that's underway. The professionals handle that. And they update us as they have updates. And so due to the end of the year and holidays, we had not gotten an update, but as of our last meeting that Laura and I both were in, the expectation was hopefully into the year, we would hear about that jurisdictional determination.
Okay. Chris, if you're able, can you clarify something for me when you're talking about any changes from the delineation for wetlands, et cetera, they have been incorporated into the plan, calculated into the budget. Are you talking about the $22.2 million reflected in the lease?
No, the overall construction budget for the project.
Which is more.
Yeah, I mean, the project is a $318 million project, I think was the estimate that was mentioned at County Council. Yeah, the $22.2 million is the annual lease between Allen County and the Building Corp. The Building Corp will be the entity who actually issues debt for the project. So Allen County actually issues no bonds or debt related to this project. It's the Building Corp. And so in that lease, you set up the maximum lease rate, which is 22.2. That number was derived because that was Baker Tilly's worst case scenario of where interest rates might be at the time of our bonding, given the cost of the project. And so that number was assumed at a 0.11 correctional lit, $5.925 million of edit tax contributed with a interest rate over the projections of when they made the estimates of a 1% over that. So it was like their worst case. If interest rates rise 1 full percent over that current number, we still can make the annual lease rate given the correctional lit plus the $5.925 million of edit that's pledged. In addition to that, the lease document says the county can use any other funds it wants to. The county probably gets $30 to $35 million a year of income tax in the various buckets. So in addition to the new correctional lit, if we were to have some catastrophic financial crisis in the world that caused 15, 20% unemployment in Allen County, we might, then have to dip into potentially other income tax buckets. But there should be, based on the projections from the state of Indiana for income tax for 2024, sufficient funds. And then what Baker Tilly does is they never increase beyond that number. So if the 2024 number that we think we can generate, which is 22.3 in the worst case scenario, what we adopted can meet that number, that on their chart of accounts goes until the end of the bond. So it does not take into account any potential growth in income tax that historically every year but one in Allen County for the last 30 years or so has taken place. So income tax is a reliable source for the repayment of a lease. We frequently use it in local government. The city uses it frequently for parks and community development projects. Schools use lease purchase arrangements frequently. I think when I looked it up, there were about 19 active lease purchase arrangements in Allen County between schools, the city of Fort Wayne and Allen County. We have 3 current ones at the Memorial Coliseum. We just had 2 that rolled off 2 years ago. The former last update to the Allen County Jail was done under a lease purchase with the building corp. So it's an arrangement we've used prior and is commonly used in local government.
Okay. So do you, Chris, know offhand what the annual lease rental is expected to be for county? I know we're going to see that in Baker Tilly's reports if it's provided, but do you know offhand what the expected annual cost is going to be?
Well, as the lease rental document says, it is a maximum not to exceed of $22.3 million. You don't know the exact number until you actually bid the project. So based on your estimated cost of construction, you know how much you need to bond, and then you bid the project, and then you size your bonds to the bids. And then that is when you determine the final lease rental number. So it will be less than $22.3 million. But we don't know an exact number and won't know an exact number. And so what you do is you do the maximum lease rental. And then when you have your bonds issued and that exact annual number that will be needed from the building corp, then you amend your lease and lower it to the number. That is historically how it has worked and how Barnes and Thornburg, our bond counsel, has frequently worked lease purchase arrangements.
So okay, so just so I understand it, when it says in the lease, the amount is not to exceed $22,220,000. Well, let me back up. At a rate per year during the term of this lease, not to exceed $22,220,000. That's the annual payment. The 22.2 is the annual payment, not the okay. Okay.
That's an annual lease from Allen County to the building corporation for the building corporation to pay back the bonds that it issued to construct the jail.
Okay, and that's going to be paid. Okay.
Which gets to your question about why this isn't subject to debt limitations. Allen County issues no debt. That's how the state has worked lease purchase arrangements to not be subject to. I mean, this is a state prescribed, format. It's because the county or a school corporation or whoever, it doesn't actually issue the debt. It's the building corporation who issues the debt, and then through a lease, you make the annual payments to the building corp, who then pays back. It's a pass through. It pays back the bonds that they pulled for the entity to construct the project on behalf of the leasee, which is the county.
Right, and I just want to make sure, for the benefit of everybody still here and listening, I asked Mark Cranley, for kind of legal support for that, just so that, and I expect to see that, and then okay, so do you have anything else to add, Mr. Cloud? I don't think I have any other questions for you. I know you just kind of jumped in the middle of it, but I think
that's fine. The only other thing that I would add is county council has held several public hearings. They have been engaged with the Board of Commissioners in public conversations. I've personally done at least 3 presentations on funding options to them over the last 18 months. This has every Every required public hearing has taken place. Every required resolution has been adopted to follow the state prescribed process for both adoption of a correctional lit as well as the jail lease, which those two kind of go hand in hand. And so just that council has been involved in every step of the way, and then voted several times to do all the things that's required of them under the statute, to make a finding, to adopt a lease, to adopt the correctional lit rate, to pledge the correctional lit rate. So I mean, every part of the process so far that has required public vote, those have all taken place. And Ms. Mazur and I have been involved all the way back to the beginning of the lawsuit. I was involved in mediation attempts between the plaintiffs and the county as the kind of the person being deposed on behalf of the Board of Commissioners. So Ms. Mazur was also involved in the previous federal lawsuit back in the 90s that resulted in the previous addition to the jail, which had the Bud Meek Center. So as was mentioned by Mark, it was sort of if we're going to do this, we need to do this that actually solves all the identified items in the judicial order once and for all. We've band-aided in the past. The last federal lawsuit in the 90s, we sort of band-aided our fix due to cost constraints. So that's sort of what drove the sizing, the layout, the need for acreage that was required for this, and what made the downtown location no longer suitable was a lot of the trying to do it right and do it appropriately and do it for a most cost-effective way that we could, building the size of a project we need to build, knowing that today's dollars are always cheaper than tomorrow's dollars. And so that's what drove the cost and what drove the financing mechanism of using a lease purchase, was because we needed to do a large project to solve a large problem. Other than that, Mark and Laura addressed, I think, all the points that we needed to raise.
Okay. Thank you, Mr. Cloud.
Yep, thank you.
For everyone, can we have you can indulge me a sidebar for 1 second?
Sean Collington, are you going to do any more interviews here?
I think there will probably be an opportunity for anybody that did not previously sign up to testify that would like to speak, but we'll revisit when we finish our sidebar.
Yeah.
We'll be right back.
Yeah. Okay. All right. Thank you, everyone. I do have a question for Ms. Metzer, Chris Cloud, having to do, there was comment earlier regarding testimony about the courthouse or the lease being against the courthouse. Can you speak to that?
Sure. When you do a lease purchase, if you don't want to amortize the interest in the first several years until your facility is constructed, because you can't lease something that doesn't exist, you provide a different structure to lease. It's just honestly, it saves the county millions and millions of dollars on interest. And so until the new jail facility is constructed, the building corp will engage in a lease with the Allen County Courthouse, as the building that you lease has to be at a dollar amount that exceeds what would be the interest due during the first part of the construction. It's a 3-year construction, so it's a lot of interest. It is the largest building that we have value-wise that is not already currently pledged to a lease purchase. We would have used the Coliseum. It is already pledged to its own lease purchase. with the expansion. So you're not technically taking equity in the courthouse. It's just a lease on paper so that you can save on interest costs because it saves us lots of money. So at the end of construction, when the jail is complete, the lease document actually gets amended so that the lease is with the new jail facility and the courthouse is removed. So it's really just the 3 years during construction where you have to have an object to physically, a building to physically lease in order to legally make lease payments. So that's how you don't pay the amortized interest. If we didn't, we'd be having to basically finance 3 years of interest, which is prohibitively expensive on a project of this size.
Okay, so the county has done this with other buildings, you're saying?
Yeah, well, I mean, I think
With other projects.
every
Yeah.
public entity wants to avoid, if you did a really, really small project, it may not be as necessary to amortize the interest. But I mean, this is what schools do. This is what we did on the Coliseum. You pledge a building, you lease it, and saves you the interest earnings or the interest costs.
Okay. Was this stated in the lease at all? I wasn't able to find it.
It wouldn't be part of the, well, it's in the lease in that we're both, I think it's Exhibit A lists both entities as both the courthouse address and the new jail facility address are both listed as rented. I can't remember what the title of Exhibit A is, but
Okay.
it's like
I see
the
now.
assets being leased or something, or the properties or whatever it is. So.
Okay. 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 All right.
And I'm sure if we to our bond counsel Barnes and Thornburg, we can provide whatever Indiana code citation. I mean, this is a prescribed process from the state, so we can provide whatever citations are necessary. Yep.
Please. Okay, thank you, Chris. Mr. Is it Collartine, or Sean? I'll let you. If you have comments,
Yes.
I'll entertain them. Please unmute yourself if you are. I see you. Mr. Collartine, please unmute yourself when you're ready to speak.
Is that it? Can you hear me?
I can hear you, yes. You're back on mute. You're back on mute. You might have to hold the button down.
Okay, because it keeps cutting me out. Okay, I'll hold it down. We need to go back to the origin of this whole project, and that is that the federal judge ordered Allen County to do several things. One, he said secure the safety of the location, get to capacity rather than over capacity, exercise the prisoners. Now, these are not unreasonable requirements. And Elevatus, in their first study, in their original study, who was the consultant on this project, came up, and they were hired for, I believe, $5,000. And they came up with the idea that the renovation of the existing jail would be roughly 21 million. And then almost parenthetically, it's announced in the paper to the rest of us that there's also projections of if we build a new jail, and that was going to be on the order of $250–300 million. Well, the obvious public choice is let's explore the $21 million option, but that was never considered, or certainly not publicly considered. So we're sitting here fighting something where there could have been an alternate to this and maybe a reasonable compromise. Instead, we're stuck with a $316 million project. And I would like to point out that the judge's requirement were not extensive. They could have been solved a lot more simply and easily than what we're being faced with this whole thing. So let me point out that we as members of the public object to overspending like this. This is exactly why people go crazy. Let me point out other jails that have been built in the last 7 or 8 years. In Indiana, Delaware County, they got 500 beds for an average bed cost of $90,000. This was in October of 20. Henry County, 246 bed. There was $97,000 a bed. Muncie, that's reported in the Muncie paper. I have citations on all these. Fulton County, their beds cost 109 or 100,000. Hamilton County, 109,000. Clay County, 112,000. Vigo County, 132,000. Madison County, 162,000. Tipton County, wow, we start getting into the big numbers, 190,000 per bed. Allen County, $243,000 per bed. Where is that? What are we doing? What are we getting for this money? And all we do is flail out here in the wind because we have the political process that's carrying on behind closed doors, and they pretend that it's an open process. It's an illusion. They meet all the, they meet.
Oh,
No,
you're
you're muted again.
muted again, sorry.
There we go.
There I'm
Okay.
back on it. I relaxed my finger too much. So what happens is we are stuck with fighting a $316 million project. We're not arguing about whether their need exists. We're arguing about who's going to pay and how long. We're going to hand this debt to our children. This is nuts. It's irresponsible. One of the things that Chris Crowd points out, it says, we've met all the legal requirements. How about the ethical requirements, Chris? Where are the ethical requirements? Let's see somebody inform the public. This has all been done behind closed doors. County council barely knows what's going on. We don't get the estimated cost from the contractor until what was that? August 23rd of this year. So we're just flailing around. You know, we're just objecting, and they go, "Well, we don't have figures. We don't know. We're not sure what we're doing." Or they didn't say that. That's what we've concluded. They're not sure what they're doing.
Muted again.
Muted, yeah.
Did I lose it again?
Yeah.
You're good.
Anyhow, interrupt me in the middle of my rant. Mr. Granley said the hearing is, or the point of the hearing is this unnecessary, unwise? I would argue, yes, it's unnecessary, unwise because it's overspending. And again, I'll send you information on these other jails so that you can verify the question that is on the table. Why is Allen County building the deluxe version of this? Is this the Taj Mahal? No, it's a jail. Let's figure out how we can do it humanely and at a reasonable cost, and spend money, whatever it takes to rehab. But you can also, as part of this project, we can use some of the land out there and build it for the level 6 felonies that are awaiting trial. You know, you can do this in 100 million different ways, but our commissioners have handed us a bill of goods on this thing. Let's see, got that? Just a sec. And then we talk about how long until the commissioners in the letter of, I'm trying to do two-hand and keep the mic depressed here. This is a letter to county council, which they apologize for, blah, blah, blah. Giving the variables in the, I know, it's on the funding for this project. You find it curious that we stayed away from property tax on this thing, but it's used as the backup. Oh, it's a guaranteed. So the bonders and everybody would prefer that, but they know that the complicating factor is referendum is involved. We can say no to that. We can't say no to this lit test. That's handed us because they've handed our representatives, our county council, a limited amount of information and not necessarily in a timely fashion. Back to the judge and his requirements. Allen County has a long-term solution. Great. Okay. You know, let's fix the jail. Let's build a jail. Okay, fine. They have not produced one short or midterm solution, which the judge has also asked for. They just ignore that. How is this possible? They say, well, we're complying with the judge's order. Judge said short, middle, and long-term solutions. And yet all is offered is a $300 million bill. And they say, well, there's our solution. Yeah, what are you going to do while this is under construction? What's your plan to handle the overcrowding that's occurred now? They don't have a plan because they can't justify anything. They'd have to do some things that would result in a long-term reduction in population. Let me see. Oops, I almost lost it again. Just a second, I'll wrap it here. I will provide you the information on the other jails. It just is unreasonable what we're doing, and we still don't have a good idea. Why, I suspect part of what's going on here in the construction and the whole thing is that the architects went to the, into the sheriff and the law enforcement people and commissioner and said, hey, give me your perfect idea of what a jail should look like. Oh, geez, here we go. Let's line it out. Well, is anybody asking a question along the lines of, are there alternate building materials that could have been used? Could we have done a different design? There hasn't been any opportunity for any of the people at the public hearings to present anything. To say, well, we're working on that. So it's all done behind closed doors, and that's what makes me crazy. This could have been handled in public. It can be done in a manner which is forthright and honest and addresses the idea that there might be other solutions. We're given one solution, and it's going to cost us a fortune, and they justify it all day long without excuse because they're just interested in advancing this particular project, not the interests of Allen County citizens.
Okay. Thank you, Mr. Collartine. I apologize if I mispronounced your name.
That's fine.
Okay, so is Alice Lipke still on? I want to give her a chance since she wants to say something.
I do not see her name listed.
Okay.
But we'll just say for the record, because the hearing recording and the video associated with it will be made available on the department's website for review at a later time. So if Alice does review this at a later time, or somebody that knows her can let her know, she can also submit additional written testimony by the deadline that was previously mentioned by Mr. Marusar.
Yes, and that goes for anybody else who wishes to speak or wishes to provide testimony. Sorry. Trying to see if there's anything else we need to see.
While he looks over his hearing notes, are there any additional individuals that are still in attendance for this evening's hearing that would like to testify that have not previously done so?
Yeah.
Mr. Fernandez, it looked like you unmuted. Did you?
Well, I mean, I want to obviously let anyone who hasn't testified that wanted to testify, but I had a couple comments on the things Chris Cloud said. I think he pointed to the 2024 income tax projections, but that would just be 1 year of a 20-year lease, the 20-year lease being proposed. So I think that's extremely limited. So I'm hoping that when they get you the data as far as these income tax projections from Baker Tilly, that includes more than just what this year's projection is on that. Also, it seemed like with not being able to lease a building that doesn't exist yet, it seems like he's kind of getting at IC 36-110-12, which talks about unoccupied buildings not being allowed to be leased. I think it says that buildings that are being improved, the structures that are still occupied but are having improvements added and stuff, that can actually be leased. So I think that kind of goes to some of the questions as far as alternatives go. If they were looking at that, if they were adding on to the existing building in some way. Then there's also the $318 million comment as far as the building fund. $22.22 million is, what the lease payments I think he was indicating are. It's like $22,220,000 over each year for 20 years. You multiply that out, that's nominally $444.4 million if I calculated that right. I know it comes in present, but if you look at the present value, it's going to be less than that because of inflation, because inflation almost always goes up, decreasing the value of things. So it comes out closer to that $318 million that he's probably talking about in terms of the construction, which is presumably pretty close to the first 3 years here of this lease here. And one more is that the Indiana Constitution, I think the municipal debt limit being referred to is Article 13 of the Indiana Constitution. And in there, it does seem to include bonds or obligations in terms of what would be an excess amount. And so I don't see how leases would not be included in the obligations if it wasn't, if the debt from the actual building corp, which I think everyone has agreed is a public agency is not included in that as well. And I know we're just talking about the lease, which we haven't got into the bonds being issued for the building corp, but at the point the bonds are issued by the building corp, I would think that that would be applicable as well. Yeah, if I'm not, again, not being an attorney, and I'm not an attorney, not authorized to give legal advice. But those are just some comments on that.
Okay. Thank you, Mr. Fernandez. Is there anyone else like to make comments again? Like, as I said in the beginning, avoid repeating comments to what has already been said.
Emmanuel Ortiz does have a hand raised.
Okay, Mr. Ortiz.
Yes, thank you.
There's another computer in that location that's logged in. Can we mute that mic or?
Yes, 1 second, thank you. Sorry. First of all, I just want to add my voice in support to all of those. You can hear me okay?
Yes, I can hear you.
I add my voice to all of those questions and concerns and contestations that have been provided by the other participants in this conversation. I do have a couple of points. One is a question. It's my understanding that an increase to property taxes may be subject to a referendum by the voters of Allen County. If that is the case and the property taxes were included in this lease agreement, wouldn't that mean that it would be subject to a referendum by the voters? And by not holding a referendum because of the inclusion of the property tax clause, could the legality of the lease agreement be called into question? So that's a question that I have. I also just want to add that the commissioner's failure to seriously consider and pursue an independent feasibility study, not one conducted by the very design firm that is set to profit from the building of a jail, and the larger the jail and the greater the price tag, the more profit they would make, and to consider an overhaul of the current jail site at a fraction of the cost of the current plan would contribute to seriously questioning the necessity of this particular lease at this particular price point and the taxation of Allen County workers at this level. I also think that the concerns around the wetlands and the National Environment Policy Act need to be taken into serious consideration. And I think that concludes my points in addition to every other point that others have made. Thank you.
Okay, thank you. Okay. Okay, is there anyone else who would like to speak?
I do not see any additional individuals with their hand raised, or do I see new comments indicating that someone else would like to testify?
Okay. As I said, there will be opportunity to provide additional written testimony, whether you spoke here or you have not. Like I said, it's by the end of the day on January 18, 2024, so that's 2 weeks from today. For those who attended, thank you for being here. For those who have spoken, provided testimony, thank you for testifying. Let's see, conclude remarks. So again, if you want to provide additional testimony or evidence, please submit it you can do so either by email at hearings@dlgf.in.gov. Some of you are familiar with that email address. If you're going to submit it by regular mail, again, the mailing address is Department of Local Government Finance, 100 North Senate Avenue, room North 1058B, Indianapolis, Indiana, 46204. For this, if you're able to do so, we ask that you try and submit via email. It will ensure timely receipt of evidence and also reduces, it also comes directly to me or the hearings inbox. If you have no other option but to mail written evidence, we'll consider it timely if postmarked on January 18, 2024, even if we receive it after that date. But if you submit by email, it has to be to the department by January 18. Again, thank you for being here, for attending, for speaking. If you have provided testimony, thank you all for your courteous attention on this matter. Like I said at the beginning, the issues brought up, raised, and evidence presented either at both at this hearing and what will be provided as supplement will be considered. After this, I'll make a recommendation to the Commissioner of the Department of Local Government Finance, who will then issue an order after the hearing and receipt of rebuttal evidence on the proposed lease. Before I adjourn this hearing, are there any questions about things going forward? We're not necessarily about the lease itself, but as far as like how this process is going to go going forward with respect to this remonstrance. And if anybody has any questions, feel free to contact, send an email to the hearings inbox, or you can call our office, and we can be able to answer the questions. Again, thank you all for being here. The time is now 6:34 p.m. Eastern Time. No other matters being brought before me today. This hearing is now considered adjourned. Thank you.